Assalamu alaikum, sir. My name is Saffi Ur Rehman, and today my topic of presentation is tracing the concept of negotiation. My topic is basically on negotiation, not in Pakistani legal system. So, if we come towards negotiation is when two or more people talk to each other and they try to reach an agreement. They share what they want, listen to the other side, and they try to find a solution that works for everyone. Negotiation is basically a mode of dispute resolution, and there are basically two modes of dispute resolution. One is compulsory formal adjudication, and another is consensual informal process, and it is known as alternative dispute resolution. Every negotiation has its roots in different ADR modes such as mediation, conciliation, arbitration. In mediation, it is known as assisted negotiation, and in conciliation, it is known as indirect negotiation. There are different advantages of negotiation. First of all, it is confidential, it is economical, and it is also flexible. Uh, the term negotiation is very old. It is as old as human history itself. This mode is only negotiation is only successful if both parties are willing to resolve the dispute. If they are not willing to resolve the dispute, so negotiation isn't going to work well. So, if we come towards the meaning jurisdiction of the term negotiation has its Latin origin and it means carry on business. Technically, it has got three meanings. It has got meanings in law of instrument, it has got meaning in international law, and in negotiated justice. If we come towards the international law of instruments, in law of instruments, negotiation means that giving someone a check or note in a legal way so they can receive the payment. It is basically the basic definition of the law of instrument. So if we come towards the international law, in this, negotiation refers to a diplomatic procedure whereby representatives of states, either by direct personal contact or through correspondence, engage in discussing matters of mutual concern, and they try to resolve the differences. And the third one is the negotiated justice. Negotiated justice means to solve a legal cases through agreement instead of a full trial in court. In simple words, it means that negotiated justice is when people involved in a legal case agree on a fair solution without going through a long court process. Like they don't want to go for a lengthy litigation, but they just want to resolve matters within themselves. Its examples include like plea bargaining. Plea bargaining is when the accused agrees to plead guilty in exchange for a lighter sentence. So, if we come towards some of the basic things of negotiation, like negotiation is a direct communication mechanism. Its main objective is to resolve the dispute between the parties, and the outcome of negotiation is basically non-binding. And procedure and formulation of solution remain in the control of the parties. Like if both parties want to resolve the disputes, then only in that case they can resolve the dispute. Otherwise, the dispute isn't going to be settled. So, if you come towards the strategies of negotiation, there are basically four phases of negotiation. One is preparation, opening, bargaining, and closing. So, if we come towards the preparation phase, the preparation phase in negotiation is basically the first step where you get ready before talking to the other side. Preparation phase involves gathering information and understanding the needs and interests of the other parties. During this phase, you have to understand your goals, like what do you want from the negotiation, and you have to know your limits, like what's the lowest deal you are willing to accept. And you have to learn about the other side as well, like what they want and what might they agree to. So another thing is you have to plan your strategy, like how will you approach the conversation. So next phase is basically the opening phase. The opening phase in negotiation is when the actual conversation starts between both sides. It's like the first meeting where everyone shares their side of the story. So during this phase, you have to both parties have to introduce their position, like what they want or expect. People try to build a good atmosphere, and each side tries to listen and ask questions to the other side. So the third phase is known as bargaining. The bargaining phase is one of the most important phase in negotiation. It's basically uh, core negotiation occurs here. In this phase, both parties make offers and they have to compromise and they reach an agreement. One side make argument and they receive a counter argument from the other side. So basically, the core negotiation occurs in bargaining. So during this phase, both parties negotiate on important points and they may give up something small to get something more important. So the fourth phase is the closing phase. The closing phase in negotiation is the final step where both sides agree on a deal and make it official. It's like basically shaking hands after agreeing on everything. They make sure that everything is clear and there are no misunderstandings. The agreement is usually written down or signed. The goal is to finish the negotiation smoothly. So, if we come towards negotiation again, a successful negotiation process shall always need some essentials. Like there should be cooperation between the parties. Like both parties are willing to sacrifice some things in order to get something more important. Avoidance from irrelevant discussion. They should also know about the time constraints. Like they should not waste time. Belief of the parties that no other mechanism would bring a better solution than negotiation. If they are willing to solve case to negotiation, then this strategy is the best one. So another one is belief of the parties that a mutual agreement is not something impossible, and admittance to that to leave some and to take some is the fundamental feature of the process. So cooperation means that the party should sacrifice his own interests. Such negotiator is basically known as negotiator. And another type of negotiator is one that wants a win-loss situation, like he wants to win at any rate. So such type of negotiator is called competitor. There are two strategies of negotiation. One is competitive and adversarial strategy. Another one is integrative or interest-based strategy. If we come towards the competitive strategy, the party wishes victory at any rate, even at the cost of the other. He takes an extreme position and tries for one-sided gains. With him, there is a very limited scope of concession. He doesn't want to make any concession. He just wants a win-lose situation. Like he wants to win and he wants another party to lose. He doesn't want a win-win situation on both sides. So to achieve this goal, the negotiator uses various tactics and generates maximum pressure on the other negotiator. This is called the positional bargaining or distributive bargaining. And the moving of the parties from their original position to a compromising one is basically known as negotiation dance. In situation like this, the chances of arrival on an agreement is highly decreased. The competitive strategy is successful only when the other party is avoidance. So, if we come towards integrative or interest based strategy, the focus remains on amicable solution. The peaceful settlement is the main objective. The strategy adopted is to make concession to ensure joint gains and to maintain good relationship with each other. It may sometimes demand the sacrifice of one's own interest. For this kind negotiation, for this negotiation, it also has an alternative name which is known as the soft negotiation strategy. And this approach basically has some advantages. Its advantages are it reduces the chance of breakdown. It results in a better agreement based on a win-win situation. It closes the chances of repudiation of the agreement in the future. It results in improved organizational effectiveness. It ensures the restoration of ties between the disputing parties. That's all from me. Thank you.